How to find this information. Daniel Owen et al. v. Watchtower Bible and Tract Society of New York, Incorporated et al. This is the appeal case page. This is the case page. Order. Filed, November 6, 2024. Supreme Court of the State of New York Appellate Division, 2nd Judicial Department. Argued October 8, 2024. Decision and order. In an action to recover damages for personal injuries, the defendant governing body of Jehovah's Witnesses, hereinafter the governing body, appeals from an order of the Supreme Court, Kings County, Sabrina B. Kraus, J., dated November 15, 2023. The order denied that defendant's motion pursuant to CPLR 3211-A, to dismiss the complaint insofar as asserted against it. Ordered that the order is affirmed, with costs. The plaintiff commenced this action pursuant to the Child Victims Act against the defendant governing body of Jehovah's Witnesses, among others, alleging that the governing body was liable under different theories of negligence for sexual abuse perpetrated against the plaintiff by a ministerial servant named Robert Warren during the years 1965 to 1971, when the plaintiff was a member of the defendant Middleport Congregation of Jehovah's Witnesses, Middleport, New York. The governing body moved pursuant to CPLR 3211-A, to dismiss the complaint insofar as asserted against it, contending, among other things, that dismissal was warranted pursuant to CPLR 3211-A, 7, and 8. In an order dated November 15, 2023, the Supreme Court denied the motion. The governing body appeals. For the reasons stated in RKJW 1 Doe v. Watchtower Bible and Tract Society of New York Incorporated, decided herewith. The Supreme Court properly denied the governing body's motion pursuant to CPLR 3211-A, to dismiss the complaint insofar as asserted against it. RKJW 1 DOE v. Watchtower Bible and Tract Society of New York Incorporated et al. This is the appeal case page. This is the case page. Order. Filed, November 6, 2024. Supreme Court of the State of New York Appellate Division, 2nd Judicial Department. Submitted October 8, 2024. Decision and order. In an action to recover damages for personal injuries, the defendant governing body of Jehovah's Witnesses appeals from an order of the Supreme Court, Kings County, Sabrina B. Kraus, J., dated November 16, 2023. The order denied that defendant's motion pursuant to CPLR 3211-A, to dismiss the complaint insofar as asserted against it. Ordered that the order is affirmed, with costs. The plaintiff commenced this action pursuant to the Child Victims Act against the defendant governing body of Jehovah's Witnesses, hereinafter the governing body, among others, alleging that the governing body was liable under different theories of negligence for sexual abuse perpetrated against the plaintiff by a ministerial servant named Ronald Mark Harding during the years 1991 to 1994, when the plaintiff was a member of the defendant Kings Highway Congregation of Jehovah's Witnesses, Brooklyn, New York, hereinafter the congregation. The governing body moved pursuant to CPLR 3211-A, to dismiss the complaint insofar as asserted against it, contending, among other things, that dismissal was warranted pursuant to CPLR 3211, A, 7, and 8. In an order dated November 16, 2023, the Supreme Court denied the motion. The governing body appeals. Dismissal pursuant to CPLR 3211, A, 8, for lack of personal jurisdiction is warranted where a named defendant is not a legal entity amenable to suit, Chestnut v. United Methodist Church. Under New York law, an action or special proceeding may be maintained against the president or treasurer of an unincorporated association upon any cause of action, for or upon which the plaintiff may maintain such an action or special proceeding, against all the associates, by reason of their interest or ownership, or claim of ownership therein either jointly or in common, or their liability therefor, either jointly or severally. Chestnut v. United Methodist Church. Here, at the pleading stage of the litigation, the plaintiff sufficiently alleged that the governing body was a jural entity capable of being sued as an unincorporated association. Notably, the summons listed a discrete address for the governing body which was different from the addresses listed for the other defendants, including the defendant Watchtower Bible and Tract Society of New York Incorporated, hereinafter Watchtower. Additionally, the complaint alleged that the governing body was and is a business or religious entity of unknown legal status conducting business in the state of New York and that at the time of the sexual abuse alleged in this complaint, governing body's principal headquarters was located in Kings County, state of New York. Additionally, the complaint alleged that during the dates of the sexual abuse of plaintiff, defendant governing body established the sexual abuse policies implemented by Watchtower and all congregations of Jehovah's Witnesses in the United States, including congregation, established the policies for appointing and supervising elders and ministerial servants within the Jehovah's Witness organization, participated in the appointment of elders and ministerial servants, and exercised supervision and control over elders and ministerial servants, including harding. The complaint further alleged that the governing body comprises 8 members, claims to have a formal president or secretary, and has a coordinator that was formerly referred to as a chairman. The complaint further alleged that the organizational structure of the Jehovah's Witnesses is hierarchical and that the organizational head of the Jehovah's Witnesses was and is defendant governing body. As such, the complaint alleged that authority flows downward from defendant governing body to the local level of the organization, which is made up of congregations. The complaint also alleged that at all times relevant to allegations in the complaint, both Watchtower and the governing body had ultimate authority over the appointment of any candidate to various positions, including elder, ministerial servant, and district or circuit overseer, and that Harding was a ministerial servant of the congregation at the time of the alleged abuse. Moreover, in opposition, the plaintiff submitted various documents from Watchtower, including one entitled
Overview of Jehovah's Witnesses U.S. Organizational Structure.
That document stated, among other things, that Watchtower,
incorporated in 1909, is a not-for-profit corporation used by the governing body to hold title to properties in New York, print Bible-based books and magazines, and to sponsor schools for missionaries. Branch committee members and traveling overseers of the Watchtower Education Center in Paterson, New York, until October 2000. It was also used to oversee activities of Jehovah's Witnesses in the United States.
Emphasis added. That document also stated that
the governing body currently has 7 members, all of whom reside in Brooklyn, New York.
And that since 1975, the governing body has been organized into 6 committees, including a
Coordinators Committee
that
has oversight of legal matters and crises.
Based upon these allegations, the Supreme Court properly determined that the governing body, which has a separate and distinct identity from the rest of the Jehovah's Witnesses organizations, constitutes a jural entity that can be sued as an unincorporated association in New York, see Chestnut v. United Methodist Church. Additionally, contrary to the governing body's contention, the plaintiff was not required to allege that all members of the governing body authorized or ratified the allegedly negligent conduct, since the rule stated in Martin v. Curran, 303 New York 276, does not apply to causes of action sounding in negligence against an unincorporated association. Further, contrary to the governing body's contention, whether the plaintiff failed to comply with the requirements of General Associations Law Section 13 by failing to allege the existence of a president or treasurer of the governing body is immaterial, since identifying the most closely analogous officer, e.g. chairman, will suffice. Here, the complaint not only alleged that the governing body is comprised of 8 members and claims to have a formal president or secretary, but also that the governing body has a coordinator that was formerly referred to as a chairman, and that the position of coordinator rotates on a yearly basis in alphabetical order. The plaintiff also alleged that each current member of the governing body was the current coordinator. These allegations sufficiently complied with the requirements of General Associations Law, Section 13. On a motion to dismiss for failure to state a cause of action under CPLR 3211, 7, a court must accept the facts as alleged in the complaint as true, accord plaintiffs the benefit of every possible favorable inference, and determine only whether the facts as alleged fit within any cognizable legal theory. Whether a plaintiff can ultimately establish its allegations is not part of the calculus in determining a motion to dismiss. Where the complaint alleges negligent supervision due to injuries related to an individual's intentional acts, the plaintiff generally must allege that the defendant knew or should have known of the individual's propensity to engage in such conduct, such that the individual's acts could be anticipated or were foreseeable. Similarly, to establish a cause of action based on negligent hiring and retention, it must be shown that the employer knew or should have known of the employee's propensity for the conduct which caused the injury. Here, the complaint alleged, inter alia, that the plaintiff was a member of the congregation in which a ministerial servant who allegedly abused the plaintiff was an agent of the governing body, that the governing body knew or should have known about its ministerial servant's propensity to engage in such conduct, and that the conduct occurred during congregational activities and during times at which the plaintiff was under the governing body's supervision and care, custody, and control. At the pleading stage of the litigation, where the plaintiff's allegations in the complaint are accepted as true and are accorded the benefit of every possible favorable inference, the causes of action to recover damages for negligent supervision, negligent hiring and retention, and negligent training of the ministerial servant were sufficiently pleaded. The parties' remaining contentions are without merit. Accordingly, the Supreme Court properly denied dismissal of the complaint insofar as asserted against the governing body pursuant to CPLR 3211, 7, and 8.